Welcome, everybody. Super excited to have Patrick MacQueen with Medalist Legal back in the house. Patrick, thank you so much for talking with me over the years.
Oh, it's my pleasure. I've always enjoyed it.
Well, Patrick's videos that we do, these interviews, they get a lot of feedback. They get a lot of views, which I love. That means we're actually bringing information to people that have questions. And so some of those questions we're actually going to dive into today. And this was a video. It's called Subject to Wrap Financing. And if you want to watch the video, maybe you missed it, it'll be in the description. Feel free to check that out. But we're going to dive into some of the questions or comments that were in response to that. In this video, it got over 5,000 views and about 56 questions, comments. So you can see the activity. You fueled the fire there. You lit some sparks. So Patrick, before we kind of dive into the questions and comments, give us a definition or give us some insight about what the subject to wrap financing kind of encompasses. What is this?
Yeah, there's some there's a set of loans and a set of creative financing that some people engage in, and it's not a huge amount of people that do this. But there are other options other than going through someone like you for a loan, right? We don't always talk about this because they're very non-traditional. They're very risky, or they can be very risky. One of the ways in which you can do it is called a loan assumption, where you go and assume somebody else's loan. So that's one way you can do it. That's very rare, doesn't come up. It's hard to do. Lenders usually don't like that. What we also have are subject to financing, where you have a buyer who comes in and takes on the seller's loan. And so that loan doesn't actually get paid off, but the buyer takes it they take title subject to an existing loan, that seller's existing loan. So that's kind of what we're talking about when it comes to subject to. That's kind of what we're talking about when it comes to an assumption. We also have regular seller carry financing, where the seller actually finances the deal. You give the seller a note, you get a deed to the property. You also give the seller a deed of trust. And now the seller is your lender. We also have what's called a wrap mortgage, which is very similar to traditional subject to financing, where you as the seller have your loan in place. The buyer's making that payment, but they're also paying you on top of that. So it's kind of a combination of seller financing plus subject to. So that's how we integrate all of these things. There's all different ways of creative financing, but there's assumptions, the loan assumptions, which are rare. We have subject to financing, which means you're taking on the obligations of that seller. We also have traditional seller carry financing, where the seller is providing a loan so that you can buy this property from them, and you give them certain documents and they give you a deed. And then we have a wrap, which kind of is a combination of a few of those things. But they're all different ways to finance the acquisition of a property, and they're all very non-traditional ways, but they do happen, they do come up. And so it's good for people in general and real estate agents to kind of understand those, because some people aren't real happy where mortgage rates are right now, and so they're willing to consider some of these riskier deals.
I do want to clarify that if a seller has an FHA or a VA loan, those loans are assumable. And what that would mean is that the buyer would contact the seller, obviously, and come to terms on, yes, I want to buy your home. Yes, I'm interested in assuming your mortgage. The seller connects the buyer to their mortgage servicer or lender at the time. The lender will take them through kind of the loan approval process and approve the assumption. So I do want to make clear that is one scope out of the many that you talked about. And that one actually goes through the process. It has title insurance on it. The lender approves the assumption. And once approved and that closes, then the title is essentially, or the ownership is transferred over. But where we get into the kind of the rest of it is on conventional loans, on, all the others, right, that maybe aren't FHA or VA. And this is where we get into the creative financing that you speak of. So let's dive into
and a lot of fair analysis there. And a lot of people think, or a lot of people call subject to, they call it assuming, and it's not. There are those two specific scenarios that you mentioned, are the two types of loans. That's really the only time in which we can do an assumption is those two types of situations. Maybe in the commercial realm you can do it, but in the residential realm, it's FHA and VA.
And the key with this is that the lender knows about it. the lender's approving the assumption. They're doing their due diligence on the buyer. And then as we kind of move into these others, that's not always the case. And in part, it's not always the case because of the due on sale clause. So let's dive into it. First question.
Okay.
You can assume a mortgage, but through a trust acquisition agreement. Therefore, the lender cannot call due on sale. It's thanks to the Garn-St. Germain Act. Can you comment on that?
So this gets into the very definition of subject to. This gets into the very definition of a due on sale clause. And it gets into this federal law that's intended to protect people who want to prepare their estate. Right? And so when somebody wants to do a subject to transaction, the big concern on both parts, both the seller's part and the buyer's part, is really this due on sale clause. What happens when my lender finds out that I've transferred this property to someone that doesn't own the property that was never on the loan? Well, they can trigger what's called the due on sale clause. It's a typical clause in every loan document and every deed of trust that says, we found out what you just did. We are triggering the due on sale clause, meaning you sold it or you're deemed to have sold it. Now you owe the entire remaining balance. And that's a big concern because now the parties are like, well, wait a minute, what do we do now? We just triggered this due on sale clause. The lender is not happy with us. We got to pay this whole loan off right now. Otherwise, they're going to foreclose on us. What I think this person is suggesting is that if you want to avoid the due on sale clause, there may be ways to do that. And one of the ways you do that is you convey the property to a revocable living trust. When you convey the property to a revocable living trust, federal law says, yes, lender, we see that you have this due on sale right, but we want to protect people who are doing estate planning. And so we created this Garn-St. Germain Act and a couple of other acts. This was, I think, in the 80s. And that basically says, look, if you transfer your property to a revocable living trust or a family member under these circumstances, the lender can't call that due on sale clause due. They can't execute on that due on sale clause. And so what I think this person is suggesting that people do is, hey, let's convey this property to a jointly owned trust by the seller and the buyer, and we'll avoid the due on sale clause because the lender will never find out because they're going to see that this was just a trust to begin with. They can't do anything because the Garn-St. Germain Act, we're clear, we're good. End of story. We just got around the due on sale clause issue. I've seen people do it. I don't know whether it's lawful or unlawful. I think it's a little bit of a head fake on the lender, and so it's usually tough to recommend that without saying, look, these are the risks that you face. Have I ever seen a lender figure that out and call it due? No, but that's the risk, is that, hey, the lender says, hey, this is not a real trust. This defeats, the purpose of the Garn-St. Germain Act. This defeats the protections that you had there. This is not a revocable living trust set up for estate planning purposes. This was one to avoid or circumvent the due on sale clause. Again, we don't have a lot of court decisions on how that interplay works, but I think that's what that person is suggesting that people do in this circumstance.
That's very
That's a long-winded way of explaining this whole thing, how it works, and how people are trying to get around that due on sale clause. Again, is it lawful? I don't know. It seems a little bit like a head fake, and I'm not sure that you can recommend it in all circumstances. But that I think that's what they're suggesting, is that this is how you get around the due on sale clause issue.
Yeah. Thank you. All right. I find it interesting that he said the sellers can't get their property back if the buyer fails to make the payments. I had an attorney tell my friend, who is a realtor, that if there is one late payment or a missed payment, the deed goes back to the seller. Can you walk us through that?
Another good question. This is getting into some complex stuff here, which is great. And so I'm going to try to break it down as much as possible. So hopefully they didn't think that I gave the opinion that the seller is stymied and they can't do anything if the buyer or the new borrower isn't making the payments. Of course they can. They have remedies. Those remedies will be built into their documents. So let's take that out of the picture. What I think this person is suggesting is that the seller take from the buyer or get a pre-approved or pre-signed deed that basically says, look, if you ever default on your mortgage to me, if you ever default on the mortgage that you're paying, that you've taken subject to, if you ever stop paying me, I can take that pre-signed and notarized deed down to the county recorder's office and record it, and now the property is back to being mine. I think that's exactly what they're saying. I think that's problematic. So yes, it is happening. Yes, that is something that some people call it a performance deed that says, look, if you don't perform, I get to take this and perform myself and get you out of here. But what we're effectively doing here is we're circumventing the trustee sale process. We're circumventing the foreclosure process, which is a protection that borrowers have when they can't make their mortgage payments. We're basically saying, I'm taking the property back. I'm not going to give you your 90-day trustee sale process. I'm not going to go through the proofs that I need to do to get this property sold at a trustee sale or sold at a foreclosure sale. So yes, people are doing it. Yes, attorneys are advising it. I'm not going to be the one advising it, though, because I think what people are doing is they're circumventing trustee sale process. I think if a borrower ever called somebody on that, I think they would prevail and say, you need to go through this process of actually getting rid of me and doing it the proper way. So it's basically like a pre-executed or pre-signed deed in lieu of foreclosure, which again, that's usually something that gets negotiated at a later point if there is a default. But what I don't like is the whole idea of, hey, I can just take this and now you're out of here. I don't know if that's legal or not, Kelly. We don't have a lot of case law on it, but to me, you're circumventing something that borrowers have the right to go through.
Yeah, that's so interesting. And my mind is just reeling with all these different scenarios, and I think probably in your world, just like our world, there is never a one-size-fits-all answer. Everybody's got a different footprint, fingerprint. Everybody's got a different scenario. Every circumstance is a little bit different. So, but thank you for that. By using a mortgage service to pay and monitor monthly payments, the lender won't be able to call the due on sale, especially if the buyer has the property under a land trust. By using a mortgage servicer within 12 months, buyer can wipe out the DTI and seller will be able to obtain a loan because a third-party service provider is in hand.
Again, we're talking about ways in which to try to circumvent the due on sale clause. It sounds like they want to use a land trust. We don't really do land trusts here in Arizona. They're done in Florida. They're done in a couple of other states. So I can't really speak to that mechanism. But a lot of people will try to put these things in a trust. And what I think this person is suggesting, or what I'm hearing anyways, is that if you do it for a short amount of time, if you do one of these for a shorter period, then you can either, build up equity or pay this thing down and then you can refinance out of it or something to that effect. At least that's what I think they're saying, maybe. But if you are going to do, in my opinion, if you're going to do a subject to transaction, you need to be careful. You need to understand all the warnings. But to me, this really should be done if you're okay with all of the risks. I would only do it on a short-term basis. I wouldn't do it when you're intending to live in this property, etc. So this person mentions 12 months, and so I think they're saying, look, as long as it's a short-term, then it's easier to do, and I would generally agree with that. I just think that the longer you take these things out, the riskier they get, because your buyer can file bankruptcy at some point. They can become insolvent. The lender can detect what was going on and what happened and call that loan due. And so the longer it goes out, the higher that risk becomes. And so I don't know if that's what this questioner was asking. They threw in some concepts that we don't really see too much in Arizona. So the way I heard it was, this should be done for short-term purposes, and I would generally agree with that. Get that lender paid off as quickly as possible by either refi or what have you.
I think the last piece of that comment was considering if that seller wanted to go purchase another property. And once there's a history that the new lender for the seller, which now becomes a buyer, can document that payment is being made under this third-party service, then they're suggesting that payment can be removed from the seller, i.e., who wants to buy a property, their debt to income ratio to purchase the new property. So I think that's where, in part, that's coming from. Patrick, can you just kind of walk us through how some of these wraps work? Because I know that there's just so many different ways these things get done. But in your experience, if I have a property that I want to sell, and for whatever reason, I'm deciding that I'm going to sell it as a subject to or to wrap in my current lien on the property, I find a buyer. Does the buyer actually go on title as part of that? Because I've seen situations where these buyers will execute some type of agreement. Sometimes they go on title, meaning that they actually have formal ownership interest, and sometimes they don't. Can you give me some context and explain that?
I would say that in the majority of situations, they get a deed to the property. They are now the title owner of the property. So that buyer / new borrower actually has a deed to the property. And that to me is the scary part. That to me is the scary. If you're the seller, you've now given this property away. You've lost control of this property. You no longer can get in there and exercise certain things that you were previously able to do. And you've got this other loan that's sort of looming. And so that's why I think these need to be short term. That's why that you've given up title, right? You've given up title. And so the way in which some people, again, get around that is you have this sort of joint title ownership through a trust that we sort of mentioned. There's also kind of land, lease option purchases or land contracts and those types of things where the seller actually retains title. Those aren't true subject to. Those are other ways in which you can do creative financing. It's not truly a subject to. Truly a subject to in my world and the way I've seen it is, hey, I get title to this property, but I know I got to pay you and your new lender, whatever the agreed upon rate is, and I've taken subject to your lender's rights here. But I do get a deed, and that can be the scary part. That's why I think short term, if you can do these, you understand the risk, do it short term.
And I think it's important to know if you're a seller in that situation and you in fact give up the ownership of the property because the buyer now technically has filed the deed, they are the owner of record, it doesn't release your obligation on your mortgage, on your home loan. So now you just gave up ownership on a property that you're still legally responsible for. So, I mean, the complexity here is just, there's a lot going on.
Again, that's why I say if you absolutely need to do this, it needs to be short term, because the longer this drags out, that risk goes up exponentially. So there's a lot of people out there who can stomach that kind of risk, but yeah, you're still on the hook, and somebody else has title, and so you better hope that they turn around and rehab this thing and fix and flip it, and that your loan gets paid off. I mean, it's really on the seller side. We really see it in situations where people are a little desperate. They want to avoid that foreclosure. They don't want to go through that process. That somebody comes out of nowhere and says, "Well, look, I'll get you out of the foreclosure, but you got to sell me this house, and here are the conditions, and I'm going to go in and flip it, and then your loan will get paid off, and you won't have a foreclosure." But yeah, that's exactly sort of goes into why these need to be very, very short term, in my opinion.
I think you addressed this earlier on in the comments, but this one is, surely this needs to be structured such that a performance deed is signed by both parties and retained by the seller's attorney to be used in the event that the buyer is in default. So the seller gets the property back automatically. Obviously, the buyer forfeits any upfront monies or equity they may have used to acquire the property. Patrick?
I'm not doing it. I'm not holding on to any deed and making that determination. So I'm sure there's some attorneys out there that are doing it. I'm sure perhaps there are laws in other states that make that a little bit more appealing for some attorneys. But I'm not going to be the one who's participating in circumventing somebody's foreclosure rights, because I think that's what's happening in those situations. So maybe it's possible in other states. I'm not a big fan of it in general, just because again, these foreclosure statutes allow for somebody to get themselves out of foreclosure. They give a 90-day period usually. There's a process to it. And so unless that person says, I understand this, I fully waive these rights, those performance deeds can be a little suspect and make me a little nervous.
Yeah, agreed. How many of these transactions have you done? After lender calls a mortgage due and payable because we're doing so close, all you have to do is give the property back to the seller, put the property back in his name, and then I have a lease with an option to buy. That solves the problem.
I've never seen a clean situation. So I've never seen that happen cleanly, right? And I don't know if that's the correct grammatical way to say it. Somebody's like, hey, I just lost all of the equity and investment I put into this thing, and you're going to now lease it to me. And I don't, there's so many misunderstandings in these deals. Maybe that works. Maybe that's how you do it. Maybe that's the perfect way to do it. I've just seen too many of these situations where a borrower doesn't understand what they're getting into, or the seller doesn't truly understand what they're getting into, what the seller doesn't understand what they're giving up. And so in that situation, trying to explain it to all of the parties and make it make sense and put it in the legal documents to make it make sense. Yeah, maybe that works. Maybe that's the brilliant way around it. I just have concerns that people don't understand it or aren't going to honor it.
Yeah.
So yeah, maybe that's working for some investors out there who are doing this, but I see a lot of problems. And usually we see it when we're not the ones putting these together. We're seeing them when somebody comes and says, hey, I don't know what I signed here, but I don't like this and I don't understand it, and I need to get out of this, whether it's on the seller side or the buyer side.
Right. So let's kind of do a scenario. Let's say that I'm the seller and I'm going to sell this property that has a $200,000 lien on it, and I'm going to do it with this subject to kind of financing scenario. And I'm going to sell it for $400,000. You're the buyer. You're going to give me $100,000 as the down payment. And now you become the rightful owner of the property. The deed's in your name. My lender finds out about it. My lender calls my note due and payable. And I'm going to come to you and say, hey, Patrick, I need you to sign this back over to me. And you're going to say, hey, Kelly, where's my $100,000? And I'm going to say, I don't have it. This is where I can see this type of scenario. It's just one of probably many, counters to this suggestion. And I think you're right. It's just the ethical part of this, the actual, just the reality of even if people are ethical, maybe they don't have the $100,000 to get back. And now you get into a fight. You as the buyer aren't going to release it. You got your lender potentially now foreclosing because of the due on sale. It's just a hot mess.
It is. It really is. And that's, there's just so many people just don't understand exactly what we're doing. It sounds cool. It sounds awesome. Sounds like you can make a lot of money. You can be your own lender. You can make money on the spread between your 3.5% loan and the new rates, 7%, whatever. Oh, that sounds great. But ultimately they're a pain in the butt. They're headaches and they're very, very risky.
Yeah. Well, Patrick, thank you so much. If you want to watch the original video, it'll be in the description. And if you have additional comments and questions, please note them below. Patrick, I appreciate you. Thanks for your insights.
Absolutely. Thank you.